My name is Matthew Tyler. I'm from Kingsbridge. I'm going to be your speaker today. I'm doing this presentation on behalf of Realtime Recruitment, and yeah, essentially it's going to be a questions and answers style format. I've got a list of questions that have already been submitted here, and there is going to be a time at the end of the presentation for a couple of your questions to be answered. So what you'll see is a chat function at the bottom of the prompt, the interface that comes up. Enter any questions you've got into there, and I'll try and get through them as and when I've got time. To be clear, there are going to be a couple of questions that I might not be able to answer depending on what context comes up, because my remit is around IR35. I know already there's been a couple of questions that have been submitted that are slightly more tax-based. I'm not going to be able to help you on those. For example, the illustrations of take-home pay between an umbrella company and a limited company, or an example of difference between inside and outside of IR35. Those sort of questions you should, or ideally, want to be directing towards your accountant. The reason I'm not able to field them is because there's a lot of moving parts to those questions. For example, what your expenses are, how much salary you take, what your actual earnings are, whether there's any income from other sources. Your accountants are best positioned to combine all of that information together and give you an accurate answer. So I won't be fielding questions such as that, but anything IR35 related, I should be able to answer for you. So jumping straight in with the first question that's on the panel here, which is, what is IR35? So in a nutshell, IR35 is a bit of legislation that was introduced by HMRC in 2000 to try and counteract what they saw as being the rising threat, and I use quotation marks there, of disguised employees. So people who were doing the same sort of work as an employee, but just operating via a limited company. They were controlled by the client. They were providing their personal service. There was just an ongoing contract for forever. All of these people who were engaging as disguised employees were doing so just to pay a reduced amount of tax. HMRC didn't like that. They introduced IR35 to try and counteract it, essentially under the guise of making sure that everybody pays the correct amount of tax. It has spiraled out of control a little bit since then, shall we say, and HMRC estimated there was an awful lot of non-compliance going on, hence why they're changing the rules as of April to make it so that the end client and agency for medium and large companies are responsible for determining status, not the contractor. That has been done in a move, supposedly, to try and make things easier to police on all sides and make things a bit fairer. Next question, when does it officially start? So IR35 as a rule set has been in existence since the year 2000. Since 2000 through to 2017 for the public sector and 2021 for the private sector, it's been the contractor's responsibility to determine status. It's, ultimately the contractor is the one who determines whether or not they're inside or outside of IR35 and pays tax accordingly. Since 2017 in the public sector and since 2021, April 2021, in the private sector, that responsibility has shifted. It's becoming the responsibility of, as I mentioned a little bit earlier, the end client to determine the status and pass that down the contractual chain to the contractor. So instead of the contractor bearing the liability for a wrong decision, it's the end client or fee payer, depending on exactly how the setup is arranged, who will be responsible for determining the status of the contractor and bearing the liability if that decision is wrong. Arguably, that particular setup is a slightly better way of going about it, because ultimately it is the end clients who had a lot of control over whether a contract is inside or outside of IR35, and previously, because they had absolutely no risk from an IR35 investigation or any liabilities, end clients or agencies just didn't care. It does, however, cause a few problems from the contractor's perspective, because obviously it just strips control out of your hands, which is, the whole point of being a contractor. So, do I have any employee benefits if I'm determined to be inside of IR35? Long story short, no, you don't. It's all of the negatives with none of the positives. There is a difference when it comes to IR35, being an employee for tax purposes and being an employee for employment/legal purposes. Being an employee for tax purposes means you pay tax the equivalent of an employee. That's it. No additional benefits, no thrills or anything like that. Being an employee from a legal or employment side of things means that you do get those benefits. When IR35, where as far as IR35 is concerned, you are an employee for tax purposes only. So yeah, no employee benefits if you're determined to be inside of IR35, unfortunately. How will this affect agency workers? Is the next question. So it won't really. It's not really intended to apply to agency workers operating via like an umbrella company or something similar to that. IR35 as a rule set only applies to limited company contractors and partnerships. So it shouldn't affect agency workers. So next question. Will it affect all self-employed sole traders or just limited companies? So very similar to the previous question. No, it won't. Sole traders are subject to something that's referred to as employment status, not IR35. Employment status works in a very similar manner to IR35, except for it's more focused on the test of control than it is for the others, which is substitution, mutuality of obligation and control for IR35. For employment status, it's supervision, direction and control, mutuality of obligation, and substitution or personal service takes a distant third in that respect. But the rule set that's coming in April 2021 will not apply to sole traders. They're subject to an entirely different set of laws. Next question. What if I'm contracting for an Irish-based company and pay your taxes in Ireland but have a contract with the UK? What about dual taxation arrangements between UK and Ireland? So this question, or a variation of this question, comes up quite a lot in some of these questions. If you are an Irish-based company and you pay Irish taxes, then you are not a tax citizen of the UK, and thus IR35 isn't intended to apply to you. Even if there's a dual taxation agreement, it won't apply. Yeah, IR35 only applies in the event that you are a UK taxpayer and your end client is a UK-based entity. There are a few caveats to that in terms of the UK-based entity for the end client, but I'll get onto that in just a minute with a more relevant question. Speaking of which, next question, can we still work contracts in Europe? Yes, you absolutely can. The way it works is that initially you need to be looking at whether or not the end client is a UK-based entity or not. If it has no UK-based ties, the new rule set won't apply. You will be responsible for determining your own status, again, assuming you're a UK taxpayer. If the end client is based in, say, France, but has a UK arm or branch or is part of a larger group of companies that has a UK presence, then that end client will need to consider IR35. Okay. If they have no ties to the UK, they don't need to. If they have any ties to the UK, they will need to. That only counts, again, if they're a medium or large entity as per the Companies Act. If they're a small end client, and this goes for inside of the UK as well, there is no requirement for that end client to determine status on their contractors. It falls back, once again, onto the contractors. Okay? So, if a paying company goes inside of IR35 and the contract goes through payroll, who gets paid? The employee, the company, or the employee? It's the employee. So the way that it would work is the fee-paying entity would essentially put the individual on their payroll and pay them directly. Next question. What controls could you put in place, or should you put in place, to make sure the current contractors have had the right determinations? This is a good question. There are a lot of different ways you can go about trying to make sure that the contractors have had correct determinations. Previously, if it weren't so close to April, what I would have said is if you were relying on something like CEST, HMRC's tool, that it's a wise decision to put contractors through CEST, but not rely specifically on CEST and have a backup system just to double check the results. Because the problem with the likes of CEST, etc., is that they don't take into account things like mutuality of obligation to the degree that they should and case law says they should. However, what with us being fairly close to April now, revised my opinion a little bit. There is no problem with making use of CEST by itself. You just need to make sure that what the outcome says from CEST or any tool that you're using out there is an accurate reflection of how the contractor is operating. Quite often, the best way of doing that is to speak to the contractor themselves, get them involved in the process. The contractor will very quickly tell you if they think there's an issue with what you're presenting as being the contractor's status. Another way would be to have a look through your processes when it comes to, say, for example, the right of substitution, or what levels of control the contractor is subject to, employee type benefits like Christmas parties, giving contractors training, that sort of thing. If you can look through those processes and make sure you have a solid and fixed regime, if you like, for what happens in the event that the contractor wants to substitute, you can more confidently answer questions around the contractor status and know what you're going to say and know that what you are putting in the SDS or the documents is accurate. Okay. It might not ever happen, contractor might not ever want to substitute or need to substitute, but you should know what you're going to say ahead of time. Okay. Who is responsible for making a status determination statements for me as a contractor if the contract has been subcontracted several times? So this question comes down to who your ultimate end client is. Now that can be quite a difficult decision to make, but it's the person who would be deemed as being your client who is responsible for making an SDS for you. They then pass that decision down the contractual chain to the fee paying entity who is responsible for paying your company, and then that fee paying entity is the one that bears the liability for the incorrect determination, assuming that reasonable care has been taken in coming to a conclusion. For an example of what reasonable care entails, what you want to be doing there is having a look at Employment Status Manual, ESM 10014. If you give that a look online, HMRC's own documentation around what reasonable care is will give you the details there. So yeah, it's all about determining who your ultimate end client is, really, when you're trying to figure out who is responsible for making a status determination. If, for example, you've got ultimate end client, then you've got agency 1, 2, 3, then contractor, and then subcontractor, and then you've got a very complex chain there. And you want to be making sure that you're asking the question as to who the end client is. Who are you actually delivering the services to? Are you on, agency 1's premises, delivering the services to agency 1? Do you liaise with agency 1's staff? Do you liaise with the client staff? Do you liaise with the consultancy staff? Those are the sort of questions you want to be asking. Whoever you actually engage with and deliver the services to is most likely to be your end client, but again, check with the contractual chain themselves. They should be able to tell you. Okay, so next question then. When contractors engage via recruiters like Realtime for contracts, what is our obligation regarding IR35 status / determination? E.g., when it comes to getting contracts assessed by third parties, check that it's compliant and outside of IR35. So I'm not sure exactly who this question is angled from the position of. If it was angled from the contractor's position, again, it depends on whether or not the end client is a medium or large client or not. From the contractor's perspective, after April, if the end client is medium or large, the contractor has no obligation to do really anything in relation to IR35. If they wanted to, the contractor could go and do third-party reviews like contract reviews, etc. But that choice is entirely up to theirs, and really the only benefit to doing so would be to make sure that historic tax prior to April the 6th is covered off, and that they are certain of their status prior to the changes that are coming in April. If the contractor's end client is a small client, as per Companies Act, then once again, it's the contractor's responsibility to determine their own status anyway. Nothing's changing in how the rule set is handled if the end client is small. So the contractor will be it would be in their best interests, if you like, to have a contract review done, have a working practices review done, be certain of their status. Because where a contractor is engaging with a small client after April, it is the contractor that bears the liability for any IR35 decisions. If we're looking at this particular question as to getting contracts assessed by a third party from an agency's perspective, then after April, I would, or even before April, as we're seeing here at Kingsbridge actually, I would wholeheartedly encourage you to get your contracts reviewed ahead of time, or at some point at the very least within the next couple of months. When dealing with IR35, HMRC states that they want to see a compliant set of written terms alongside of a compliant set of working practices in order to judge that, I suppose, reasonable care has been taken for one part. But it is important to note that the majority of the weighting when it comes to an IR35 determination is based on the working practices, the reality of how the contract is operating, not what the written contract states. The reason for that being that with some of the larger agencies out there, I know this is a certainty, but the written terms of the contract aren't necessarily reflective of how the contractor is operating. For example, the contract could just be a generic set of terms that's farmed out to hundreds of contractors. You know, every single contract is exactly the same thing. The only difference is in the schedule. There's nothing inherently wrong with that approach, but it does kind of dilute the strength of the written terms when it comes to IR35. So it is important to get the written contract reviewed, but the majority of the weighting is going to be on how the contract is actually operating. So, next question. How can real-time recruitment help expert people outside the EU zone to ease the process of recruitment for them, if they can? If they can in general. What are the changes in April starting? What are the changes in IR35 starting in April, and how inside/outside contracts are different? So, a recruitment agency can really help the end client by offering to take on board a portion of the work in relation to determining status. There's nothing in the legislation that says that a third party can't provide a status determination statement for an engagement. So it is entirely reasonable for a recruitment company, for example, to take on board a process that lets them produce status determination statements for the entire contractual chain, so long as the end client is happy that the arrangements that you're putting forward are an accurate representation of how the contract is operating, and that they've had a chance to review it and confirm it. That's all that's required as far as a status determination statement, which is a document that's required after April. I'll explain that in just a minute. Another thing that the agencies can do is sort of work closely with the contractors to try and get a good feel for how that contract is operating, what makes them special from an IR35 perspective. Because when the client is trying to place a role, for example, they may want to get a feel for whether or not that position is likely to be inside or outside of IR35 ahead of time. And if the agency knows what sort of contracts are out there, what their strengths are, etc., it can make that process a lot smoother. So really, agencies, recruitment agencies, etc., are going to be very, very important in the new regime in respects to sort of linking together the end client and the contractors, so an accurate status determination can be made, which is a very important aspect of IR35. as I mentioned previously, if reasonable care is not taken in coming to a determination, it can cause problems for essentially the whole contractual chain, but more predominantly, to start off with, the end client. So specific changes that are happening in April, because I realise I haven't actually covered this off. Obviously, the rule set existed in 2017 for the private sector, the public sector. The same rule set is essentially being copied over to the public, excuse me, get my words out. So the rule set existed in 2017 for the public sector, and that rule set is effectively being copied over to the private sector. There are some changes being made to it. So again, just to reiterate, that process that I'm referring to is that it is no longer the contractor's responsibility to determine status. That responsibility is being shifted to medium or large end clients that have some link to the UK. If the end client is small or outside of the UK entirely, then it's the contractor's responsibility to determine status, or it's basically not relevant depending on the contractor's tax status. The changes that are happening between what happened in 2017 and what's happening in 2021 is a few things that actually benefit the contractor. Firstly, a status determination statement needs to be produced. A status determination statement will outline precisely why that contractor is inside or outside of IR35. So it should say things like the contractor doesn't have the right to substitute, they're working under the control of the client, they are subject to appraisals or disciplinaries, they have to seek approval for time off, there's expectation of continuous work, there's no end date to the contract, things like that. All the facts that basically says this contract is inside of IR35, or likewise, if they're outside, all the facts as to why the contract is outside of IR35. That document is passed down the contractual chain, and at the same time, a copy is passed to the worker, the actual contractor doing the work. Previously, in the public sector, there was no obligation to tell the contractor why they were inside or outside of IR35. Secondly, there is a dispute process that is being made available for contractors or agencies, even anyone in the contractual chain, basically, to raise a dispute if they don't agree with the decision that has been made. So if, for example, the contract takes a look at their status determination statement and says, well, no, I can substitute, I've got proof here, I've done it in the past. If they present that evidence to the end client, then the end client needs to consider the evidence that's produced and then revise their report accordingly. That can take the form of a client basically saying, we've had a look at your evidence and we don't believe it is pertinent. Or it can be a case of, we've had a look at your evidence and yes, we are making some changes, here's what we've made. At that point, a new SDS is updated and issued down the contractual chain. And the way that dispute process works is that the contractor has the ability to raise a dispute at any point in the contractual period. And once that dispute has been raised, the client has 45 days from the point the dispute is raised to respond to it. Same process applies for the agencies, etc. If an agency doesn't agree with the determination an end client has made, they can also raise a dispute and the client has to respond to it within 45 days. The only slight caveat there, as I say, is it is a client-led dispute resolution process, which means by and large the client has control over whether or not they take it seriously or not. What we're finding though here at Kingsbridge is that the most clients are taking that very seriously. So, bear that in mind. So, next question. After that, I appreciate rather beefy question. What purpose does a timesheet serve if I already have a statement of work rate agreed already? If I conduct the work in 1 hour or 12 hours a day, then that is under my control and the client gets invoiced a fixed price. Simply put, a timesheet is going to be considered of very little standing when it comes to IR35. Quite often, a timesheet is used simply as a means of budgetary control of the client. It isn't intended to control the contractor in any way, means or form. If you are already invoicing via well, if you're already invoicing and you're putting your hours on there, then that's probably the best way to go about it. But using timesheets isn't going to hurt. And to some degree, using a client's self-billing system isn't going to provide too much of an issue either. As I say, the question that needs to be asked there is as to why the client is using that system. If it's to control you in some way or form, then you've got a problem. If it's just to manage their own budget, then there's no harm in using it. There are bigger fish to fry when it comes to IR35. So, next question. My contract with the end client is being changed to an outcome-based delivery approach. What are your thoughts on this? Fairly broad question there. But if we're talking outcome-based delivery approach, whereby, say, for example, the contractor gets paid upon delivery of set milestones or set deliverables, then arguably that can be a good thing from an IR35 perspective, because it means that the contractor has the ability to profit from sound management of their business. If, for example, they've got 6 deliverables and each deliverable is estimated to take about a month, and the contractor finishes all 6 deliverables within 1 month and gets paid for all 6 deliverables in that 1 month, the contractor is then free to move on elsewhere and, get a new contract in another position or another place, and start earning more money at that point. Likewise, there is a financial risk aspect to it, in that if the contractor takes 12 months to finish those suggested 6 months worth of work, then the contractor still only gets paid the same amount as was originally agreed, and the contractor loses out on the ability to work elsewhere, earn more money, etc. If all that's happening is that the contract is being changed so that there are now deliverables in there, but the way you're being paid isn't changing, the way you're operating isn't changing, then there's not really going to be a lot of difference from an IR35 perspective. Okay, so there needs to be some tangible potential negative or potential positive to having an outcome-based delivery system for it to really have much of an effect on IR35. A couple of extra questions we've got here. So this one's a big one that I have heard quite a few times actually, which I will address my thoughts on it here. And bear in mind, it is only my thoughts. I'm not HMRC, I can't say with any certainty. There have been rumblings of IR35 being delayed once again. Some contractors have gone as far to say they think that IR35 would be cancelled altogether. What are the chances of IR35 being delayed or cancelled? Why do you think it will/won't? Simply put, I don't think it will be cancelled. I don't think it will be delayed. The rationale there really is that HMRC bumped it back a year originally because of COVID. Since then, they've had to output a lot of money in respect to the job retention scheme and the such. They need to start recouping that money, and IR35, or the changes to IR35, I should say, the new legislation coming in, is a very easy win for them. The unfortunate truth is there's going to be a lot of companies out there that start pushing contractors inside of IR35, which is instantly going to be an increase in the amount of money that HMRC is collecting in respect to tax. It's a very quick and easy win for them, especially now that companies have had an extra year to prepare for IR35 coming in. If IR35 were to be cancelled, and I don't think it would be, then HMRC would need to introduce something which is very similar in nature anyway to cover it off. There's always going to be that gap where people who are disguised employees, if you like, are trying to profit from the system at the expense of legitimate contractors. So there will always need to be some form of rule set in there to try and stop that happening. So even if IR35 were cancelled, there would be something to take its place anyway. So I don't think IR35 is going anywhere anytime soon. We may see more revisions to it, granted, but it's not going to go anywhere. And I'm 99% certain that it's going to be coming in April 6th. There is always the slim chance that HMRC will push it back again, but as I say, they need to start earning money, and this is a no-brainer for them, really. Final question that I've got here then would be, it's another offshore working one. So just to reiterate on this point, so in the HMRC webinar this afternoon, the situation of a contractor who is working from outside the UK was briefly covered. This timing is great as I've just chatted to a contractor about tomorrow's event who is temporarily residing in New Zealand, but will be taking on UK-based contracts. He was under the impression that IR35 wouldn't impact him as he isn't in the UK. Could we have some clarification about this? Yes. So as I mentioned previously, the first port of call is, where is the end client based? If the end client is UK based or has ties to the UK and is medium or large, then from the off, that end client will be responsible for determining IR35 status. The next step is to have a look at the individual who's being engaged. Is the individual a UK taxpayer? If the answer is yes, then in that situation, the end client determines contractor status and the fee payer pays the fees accordingly. They either pay them as if they were inside of IR35, i.e. PAYE rates or equivalent to, or they pay them as if you're outside of IR35. Going back, if that end client is medium or large and is based in the UK or has UK ties, but the contractor is a non-UK taxpayer, so they're based in this case, New Zealand, then no, IR35 won't need to be applied because the contractor is non-UK based, doesn't pay UK tax, isn't subject to HMRC. Taking that back again as another step, if the end client is a small company but is and is based in the UK and the contractor is a UK taxpayer, then the contractor determines their own status for IR35 purposes. Once again, going back to the start, small client, non-UK taxpayer. Same rules apply as previous. The non-UK taxpayer isn't subject to HMRC, doesn't need to bother with IR35. Finally, the end client is non-UK, doesn't have any links to the UK. If the contractor is a UK taxpayer, the old rule set applies. The contractor determines their own status from an IR35 perspective. Once again, if the end client is non-UK based and has no ties with the UK, and the contractor is non-UK based and isn't subject to UK tax, then IR35 doesn't apply because HMRC have absolutely no grasp on any part of that contractual chain. Okay. So that's all of the prescribed questions that I had to go through. So if there are any individual questions that want to be asked, now's the time to ask them.
Hi, Matt. There are a few questions that have come through on the question section. So the first question is, would a small subsidiary of a larger group be classified as a small business for IR35?
No, simply put, straight off the bat, they wouldn't, because they're part of a larger group of companies. If the larger group of companies is tied together, even if they're all small companies, if collectively they would be a medium or large company, that's what counts. So yes, they would need to decide IR35 status on their contractors.
A recruiter was advised the contractor last week that the employer wanted to move across by the 1st of February into PAYE. As from the 1st of February, even though IR35 is not implemented until April 6th. Can this be the case?
So the end client has no authority to tell you as a contractor to move inside of IR35 prior to the 6th of April. What the end client can do is say to you that they are no longer engaging contractors, or they're not willing to entertain a contract with you if you aren't via an umbrella or something like that. But they can't tell you how to run your company technically until the 6th of April. Before that time, entirely under your control. If you don't want to move inside of IR35, you don't have to, but be aware that there will be, or potentially will be, repercussions from a contract perspective. Right. Just scrolling down. So there's a question here. Can I dispute or argue if I've been given an inside determination, inside of IR35 determination? As mentioned previously, yes, you can. However, it is worth pointing out that the dispute resolution process technically doesn't start until the 6th of April. It isn't a requirement until the 6th of April. So if the end client has provided you with a status determination statement already, which I would say is probably the correct thing for them to have done if you have a contract that straddles the 6th of April, if they honour a dispute is entirely under their control. They don't have to offer a dispute resolution process until the 6th of April. So bear that in mind. But yes, you do have the ability to dispute it. A contractor here has been deemed as being inside of IR35 despite being an Irish registered company and paying tax in Ireland. As mentioned previously, if the end client is UK based and has UK based ties, then they initially will need to be considering IR35. But if the contractor doesn't pay UK tax in any way or form, then it simply doesn't apply. Yeah, so the end client doesn't need to worry about that contract from an IR35 perspective. So in a nutshell, with this particular engagement where the end client is telling that contractor that they are inside of IR35, the end client is in the wrong in that situation because the contractor is a non-UK taxpayer. Okay. Next question. Do you see statement of works becoming more commonplace as opposed to modern day standard contracts? So I'm assuming in this situation, we're referring to statement of work here as being an outsourced service provision. There are a lot of different names flying around that mean precisely the same thing, but there's also a lot of double meanings to these names, like statement of work contracts. I've come across them previously, not in the format that they're being used currently. So what I'm saying is an outsourced service provision whereby the end client, say for example, wants a building built and engages an outsourced service provider who will take on all of the work. So the end client says, here's what I want doing. I want this building. I want it by this date. Crack on with it. The outsourced service provider then takes that work on, locates architects, builders, bricklayers, plumbers, engineers, and builds that building and manages that process themselves by being the point of contact for all of the contractors they're engaging. Those contractors have virtually no interaction with the ultimate end client who has ordered the building. They only liaise with the outsourced service provider. Then, when the project's finished, the outsourced service provider then hands the keys back over to the end client and says, here's your finished building, hope it's up to your standards, etc. If we're using statement of works to mean that style of arrangement, I can see a lot of agencies, and I have seen a lot of agencies and end clients make use of that to try and avoid IR35. I think we will see an increase of those in the short term, but consequently, as a resultant of all of this, I can see HMRC crashing down on it a little bit. There is also the potential risk that if it's not a genuine outsourced service provision, so you just dress it up to look like one, but continue to operate in a traditional contractor agency and client arrangement, that there's going to be some risks and penalties in there that haven't really been considered and can present a problem. So yes, I will see it being more common, but be very careful about how you set it up in essence. From a contractor's perspective, why have contract reviews for a small company engagement if depending on the number of employees or annual turnover they will be outside of IR35? A very good question. If you have a good number of employees under your wing, or you're earning particularly high income by the company, there's a good chance that IR35 isn't really intended to apply to you. It's only really supposed to apply to small limited companies where there's only like 1 or 2 people in the company. If there are 5 or 6 employees in the company, then it's going to be a lot harder to argue that they are essentially operating as a disguised employee. But it is worth pointing out that IR35 is assessed on a contract by contract basis. So if the individual, if for example, there's only one person in the company who is, say, a director of that company, paying themselves a low salary, high dividend, they're the only person in that company who can fulfill a role that's been offered by an end client, then there is a risk that that might be within the scope of IR35, and thus you should be considering. It's a low risk, but there is still potential there because you can't substitute with anyone in your company, so you may as well be the only person who can do the work. And all the arrangements for that end client could be awful from an IR35 perspective. So don't just assume it doesn't doesn't apply to you. And for a very small cost, you can get some sort of surety, if you like, that your engagement is outside of IR35 should HMRC ever come knocking. So I'm contracting through my limited company now, but client is risk averse and deems from the start of April any contractors inside. Have any arguments or options? This is a bit of a tough one. Technically speaking, the end client has all of the power come April to say that you are inside of IR35. What they seem to have been doing there, and again, this is a generalization because I don't know exactly what your client has done, but what they seem to have done is what's referred to as a blanket determination from IR35 perspective, which is to say they're saying everybody's inside of IR35, we don't care about your personal circumstances. If you look at that employment status manual that I mentioned earlier, ESM 10014, which details about reasonable care, one of the very first bullet points you'll see in there about not taking reasonable care, an example of not taking reasonable care, is making blanket determinations and saying everybody's inside of IR35 and not taking a case-by-case approach with contractors. HMRC can investigate and can penalise clients that are doing this. Realistically, I can't see them doing it, not for a while anyway, because blanketing everybody inside of IR35 unfortunately benefits HMRC, as discussed earlier, because they get more tax. But it is within their power to do so, so you need to be pointing that out to your end client and say, look, I don't think you've taken reasonable care in coming to a conclusion here. HMRC can fine you. And in fact, they have already done so previously in the public sector for the NHS Digital. They investigated them. They came out and said, basically, yeah, we agree with your determinations, but you didn't take due care in coming to a conclusion on those determinations. We're penalising you for it. So there is precedence for it, and you need to be letting your client know essentially around that. And feel free to link them that employment status manual. It is a HMRC document just to prove the point. Try and persuade them that you're outside of IR35, or that you'd like a fair shot at being reviewed correctly. Another thing you can do is go to them armed, ready to go. So you could have a contract review done, you could have a working practice assessment done. If you've got any evidence that you think helped point towards you being outside of IR35, you can gather that all up and put it in alongside of your claim to the client via a dispute or something similar to say, I don't think you're taking reasonable care. Here's all the things that make me think I'm outside of IR35. Please review me properly. Yeah. So who carries the financial risk if HMRC deems that an engagement is inside of IR35, assuming that the end client has deemed it outside? Does the contractor need to protect themselves from financial risk? So this all depends on whether or not the end client is small or medium or large. So if the end client is small, it's the old rule set that applies. So the contractor is responsible for determining status, and they're responsible for liabilities if that determination is wrong. If the end client is medium or large, then it's the end client that's initially responsible for that determination and the liabilities, but assuming reasonable care has been taken, that liability then bounces down the contractual chain to the entity that's responsible for paying your company. So in a traditional arrangement, that would probably be your agency. However, when you're engaging directly with the end client, it can sometimes be the end client who is the fee payer as well as the person who's responsible for making the determination. They're the entity that bears the liability. There is no risk to the contractor from an IR35 perspective. You will see some clauses in contracts that say that the agency or end client will then seek to reclaim those costs from the contractor, and it's very important to note here, I am not a lawyer, so I can't say with any certainty on this one. There is a question mark above that as to whether that would be enforceable, seeing as it is something that's not in the contractor's control, you see. So I don't know how enforceable that will be, but again, I am not a lawyer, so I can't say with any certainty how enactable that will be. One thing you will see popping up quite often, which is entirely reasonable in my view, is the requirement in contracts for contractors to carry some form of IR35 insurance that covers the whole contractual chain. I don't think there's any issue with that because it is of benefit to the contractors quite often, as well as the agencies or end clients, because it makes you more attractive to end clients and agencies for your role. And it will also, in a lot of cases, cover you as well as the end client or agency, should you then go on to engage for a small client where the liability is your responsibility. Okay. So long story short, really, it's most of the time it's going to be your end client or agency's responsibility, but it can sometimes be that you as a contractor. What might make a determined status to be outside of IR35, because it feels like most clients are turning to be inside of IR35. It's a tough one. There are IR35 as a rule set is determined entirely on historical precedent, so case law that's been established over the years, starting with a piece of case law actually from 1968, so long before IR35 was even a twinkle in HMRC's eyes. Ready-mix concrete laid the groundwork for what would be seen as being a master-servant relationship, to use archaic terminology, basically employer-employee relationship. The three key status tests, as I mentioned to you earlier, are whether or not there's a requirement for the personal services of the individual, what level of control the contractor is subject to, which is split into 4 tests, which is what the work is, when the work is done, where the work is done, and how the work is done. So, for example, the client may decide what the work is, but the contractor should determine how the work is done. Things like that need to be considered. The final key status test is mutuality of obligation, which is a bit of a mouthful, but what it essentially means is there should be no obligation for contractors to accept, and there should be no obligation for the end client or agency to offer any work to the contractor. Basically put, the contract is there for a specific purpose. Once that's done, that should be it. The client shouldn't be then shuttling them onto project B, C, D, etc. without the contractor's explicit consent and agreement. Alongside those key status tests, there's a whole ream of minor status tests, such as whether or not the contractor takes financial risk. Does the contract look like a genuine business? Do they provide their own equipment? Do they work from the home office? Have they got any sort of large expenses that an employee wouldn't be required to bear, such as being required to carry business insurances or paying for an office separate to their home premises, software licenses, anything like that can all point towards a contractor being outside of IR35. How is the contractor treated on the client's site? Are they seen as being part and parcel of the client's organization? Are they on company organograms? Do they have a separate ID to get into the building? Does their email very clearly list them as being a consultant or have their company name in it? Things like that are all factors that will impact a contractor's status. What you need to be doing, if you aren't too sure in respect to IR35, is seeking the advice of somebody who has dealt with IR35 for a while. Obviously, I would like that for you to contact us at Kingsbridge and have a chat with us, but there are plenty of advisors out there around IR35, and all of us can give you advice on your particular status. If you have a contract review done or a working practice review done, that can give you a lot of information as to how your status sits from an IR35 perspective. But what you're looking at as a very layman's breakdown, if you like, is differences between you as a contractor and the client's staff. Are you treated differently? If there are a lot of similarities, then you probably got some problems from an IR35 perspective. If it's very clear and distinct the differences between you and your end client's staff, then in theory, you're probably going to be all right from an IR35 perspective. But obviously, it depends on your exact circumstances. So let us say HMR disputes our status as being outside of IR35. Can we dispute our status being determined inside after we pay tax and claim a reasonable amount of tax? An interesting question. The dispute process does work both ways. If you are outside but you think you should be inside of IR35, you can dispute that as per the client's dispute process. But honestly, I can't really see that a lot of contractors will want to do that, but it is a possibility. The dispute process will allow for that. Let's see, if I'm using client hardware and a client email address, would this indicate as an inside of IR35 determination? So as mentioned previously, yes, it would hint towards it, but it's only would be a minor factor, a minor status test. The more important indicators are whether or not there's a requirement for you as an individual to provide the services, or in theory, if you could provide a substitute, for example, the levels of control you're subject to, and whether or not there's any expectation of work to be offered or accepted by either party, mutuality of obligations. Using the client's hardware, if there's a good reason why you're using it, it's going to be defendable. So, for example, data protection or health and safety. Yeah, both of those are very good reasons why you need to use the client's equipment and would be defendable. Using the client's email address, that's a bit harder to argue. Again, if there is a good reason for it, it's probably going to be defendable. But if not, it's going to go down as a negative, but only a small one. Okay. I am working via a recruitment agency for a tech consultancy who provides software engineering services to a large US-based client. Who is the end client? Again, this is a very tricky question, and it's probably one that's going to crop up more and more as you head towards April. I can't really say with any certainty who is the end client because I'm not privy to the contractual chain. But again, the considerations that you need to be thinking of there is whether or not you're delivering services to the software consultancy, software engineering services, or whether or not you're delivering directly to that large US-based client. It could be that the large US-based client has outsourced the services to this software engineering services, and you're delivering your services to the software engineer, in which case the software engineer would be your end client. But again, I can't see the entire contractual chain. I can't really offer a lot of advice on that one. What you need to be doing is having a chat with the software engineer, the agency, if you like, that could potentially be your end client, and see how they see things, because if they're not considering IR35 by now, they should be. I think that is probably going to cap it off in respect to the time we've got for the question and answers here. If you have any questions or concerned around IR35, I'd encourage you to get in touch with an expert, as I mentioned previously, because we are all here to help you. And we are all trying our best to sort of make things understandable and easy for you, because IR35 is a complex bit of legislation at the end of the day. And, you know, unless you've had a couple of years experience dealing with it, it can seem very, very mucky. But yeah, thank you all for attending. And yeah, I wish you very best of luck and have a good day.